Jones,
Present.
Victoria Brash, present. Tiang Feng, Leonard Manukian, Robert Pearman,
Present.
Amanda Stilemeyer, Bob Suisse,
Present.
Sunny Ward.
Present.
Thank you. It appears that we have a quorum. I'd just like to note that that 6 members of the board constitutes a quorum for the transaction of business. The concurrence of 5 members shall be necessary for the motion to carry, except that when all 10 members of the board are present, and the concurrence of 6 members shall be necessary to constitute an act of or decision of the board. We'd like to also move to procedural matters. Be advised that all motions and seconds will be repeated for the record. Votes on all motions will be taken by roll. Please note that public comment will be limited to 2 minutes. I'd like to ask that the board note that we cannot discuss actions or any item raised during the public comment section, except to decide whether to refer the item to the board's next strategic planning session or to place the matter on the agenda for future meetings. Having said that, we will move the agenda. We're on agenda item D as in David, update by the Department of Consumer Affairs. I apologize. I skipped a procedural matter for public comment, so the chair will open the floor for public comment. Please.
This is the WebEx moderator. Sorry, we cannot hear. It's not audible here online.
How about now? How am I doing now?
Much better. And I wanted to confirm the time limit. Is that 2 minutes with a 30 second warning?
Thank you. Please.
Very good. So as I said, thank you for everything you do to support the architecture community. My name is Mark Tier. I'm the owner and CEO of Black Spectacles. For the last 11 years, we've helped nearly 100,000 architects on their journey to achieve their architecture license. One of the really strong pieces of feedback we've received from our members is how much test anxiety is a part of their exam experience. And so one of the things that we have done over the years is NCARB, who of course publishes the ARE, they, in their exam guides, have screenshots of the exam interface, which shows things like the background color, buttons, the layout, typography, things along those lines. And so presumably part of the reason they've published that is to help, architects who are preparing for the exams sort of reduce their test anxiety by getting comfortable with that exam, what to expect when you show up on exam day. So it's not a surprise. And so the question that I have for the California Architects Board is, what would be the proper route to inquire whether the California Architects Board would publish screenshots of the exam experience for the general public? Of course, it would not include any proprietary question information, just really, it's really a graphic design type.
30 seconds.
So that's my question.
Thank you. I think that it's appropriate that we basically direct the executive officer to meet with you,
Okay.
review the concerns that or the interests that you may and the questions that you may have for us, and have her bring it back to us. So that's okay.
That sounds wonderful.
Okay. Thank you very much.
Thank you very much.
Can I ask a comment? I mean, also to follow up, because I thought he was also leading to whether the California supplement, we should give the same sort of anti-anxiety screenshot, and how does that handle at all? Is that not a problem at all?
Michael Connotes, legal counsel. My apologies, but we cannot discuss that issue at this time. But we can on a future agenda if the board would like to place that matter on.
Sure, and I'll add it to the next board agenda so I can report back.
Thank you.
Thank you for your time.
Moderator, are there any public comments, for the virtual audience?
This is the, excuse me, this is the WebEx moderator. For those who are logged in, there's instructions on the screen for you. You can click on the hand raise icon, which is typically bottom center of your WebEx screen. And for those who are calling in via phone, you can press *3 from your phone to raise your virtual hand. At this time, I see no request for public comment.
Thank you very much. We will move on to the agenda item D, report from the Department of Consumer Affairs. And that's Ms. Kilcrease. Ms. Kilcrease, if you're available.
I am. Can you all hear me?
Yes.
Fantastic. Hello, good morning. My name is Susan Am I good?
Yes.
Great, thank you. Sorry about that. Good morning. My name is Susan Kilcrease of the California Department of Consumer Affairs, and thank you for letting me join you today. We are very excited to announce 2 new members of the department's executive team. Governor Newsom appointed Lucy Saldivar as the Deputy Director of Board and Bureau Relations. Lucy previously served as Chief of Staff for the Office of Assembly Member Lisa Calderon since 2022 and Legislative Director from 2021 to 2022. She also held multiple roles in the Office of Assembly Member Jackie Irwin from 2017 to 2021. Lucy is a member of the Hope Leadership Institute and the California Latino Capital Association Foundation. Shelley Jones was appointed by Governor Newsom as the Assistant Deputy Director of Board and Bureau Relations. Shelley brings 29 years of experience working with the boards. She has been with DCA since 2015, serving in several capacities with Board and Bureau Relations, as well as DCA's Strategic Organizational Leadership and Individual Development and Organizational Improvement Offices. Prior to joining DCA, she served in multiple roles at the Juvenile Parole Board of the California Department of Corrections. Please join us in welcoming Lucy and Shelley to their new roles. We're very excited they will be serving and assisting our boards and bureaus, and I know they look forward to meeting all of you in the near future. On to trainings. We have sexual harassment prevention training. As you may remember, sexual harassment prevention training is mandated for completion within 30 days of your appointment to the board and every 2 years thereafter. On October 27, DCA launched its new Sexual Harassment Prevention Training in the Learning Management Center, also known as LMS. If you completed the 2024-25 Sexual Harassment Prevention Training during the 2024-25 calendar years, the new training will be automatically assigned to your LMS account 2 months, 60 days, before your 2-year mark. If you have not completed the 2024-2025 Sexual Harassment Prevention Training, the new version was already assigned to you in LMS account on October 27th. Log in and begin the training. Going forward, the compliance deadline will either be 2 years from the last completion date for those that took the training, or by December 27th for those that did not. Upon the completion of the new sexual harassment prevention training, it will be automatically reassigned to your LMS account biannually 22 months from your last completion date. If you have any questions or need assistance accessing the training or LMS, please reach out to us at memberrelations@dca.ca.gov. There's also unconscious bias training. DCA's training unit have developed unconscious bias training for board members. This training will be added to the members' LMS accounts in November, as well as incorporated into all onboarding when new board members are appointed. You can find your training records under the transcript section of your LMS account. Again, if you have any questions or need assistance, please don't hesitate to reach out to Board and Bureau Relations. Our Promise campaign launch, State Employees Giving at Work campaign. Every year through our Promise California State Employees Charitable Campaign, State employees, including board members, have the opportunity to support the nonprofit causes that they are passionate about through payroll, giving, or one-time donations. These contributions have a positive impact on our communities and is another way for DCA to show it cares for California. The campaign runs through December 31st, and DCA will be emailing information to board members this month. In the meantime, please contact Board and Bureau Relations with any questions you would like information on how to give. Thank you for the opportunity to join you today. Please let me know if you have any questions or need any assistance.
Thank you very much. Are there any questions or comments from the board? Seeing none, moderator, please open the floor to the public for public comment in person. Seeing none, I would ask the moderator to open up the channels for the virtual participants for public comment.
Yes, those WebEx moderator, the instructions are on the screen. If you're logged in, click on that hand raise icon to raise your hand. Those calling in, *3 to raise your hand. At this time, I do not see any requests.
Thank you very much. We can move the agenda. We will go to agenda item E, and this DCA budget report by Luke Fitzgerald. I think he's virtual as well. Thank you.
Yes, good morning. My name is Luke Fitzgerald, and I'm a budget analyst with the DCA Budget Office, and I'm joined by Budget Manager Suzanne Balkus. I'd like to thank the board and executive staff for allowing me a few minutes to present on agenda item E, which is the board's expenditure projections and fund condition statement. First, I'm going to start with the board expenditures, which is on the first page of your materials. These projections are based on actual data through fiscal month 2. This report includes 2024-25 actual expenditures in green, as well as 2025-26 budgeted and projected expenditures in blue and orange. As we move toward the end of the document, you'll see that the board had a beginning base budget of $4,782,000 and is projected to spend approximately $4,627,000, creating a reversion to the board's fund of just under $155,000, or about 3.25%. The next document we're going to go over is going to be the board's revenue projections, which is on the next page of your materials. This report includes receipts collected through August and projected revenue to year end. And I'll actually go further into these projections as we transition to the next slide. The last page of your materials is going to be the board's fund condition statement. And as a quick reminder, we read this document from top to bottom and left to right. The left column is going to be the board's prior year 2024-25 actuals. This column shows the board began 2024-25 with a beginning balance of $3,868,000. The board collected $4,073,000 in revenues, with $589,000 from initial license fees, $3,249,000 from license renewals, and $235,000 from the issuance of citations, fines, delinquent fees, and other revenue. The board expended $4,672,000, which includes $380,000 in direct draws to the fund for statewide pro rata and pension payments. And again, that was in the first column. The board ended 2024-25 with $3,269,000 in reserve balance, or about 7.9 months in reserve. For the current year, 2025-26, the board projects revenues of just over $5 million, with $527,000 projected from initial license fees, $4,345,000 from renewal fees, and $226,000 from the issuance of citations, fines, delinquent fees, and other revenue. The board's 2025-26 expenditures are based on fiscal month 2 projections, and is just under $5 million between authorized expenditures and direct draws to the fund, leaving the board with a fund balance of approximately $3,385,000, or about 7.5 months in reserve. The budget office will continue to monitor the board's revenue and expenditures and report back to the board with monthly expenditure projections as we continue to close fiscal months in the current fiscal year. And then just a few final things to note on the board's fund condition. The fund condition is a snapshot in time. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. These include general salary increases, as well as employee compensation and retirement rate adjustments. The budget office includes a conservative ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. You'll also notice that revenue is projected with the historical high-low trend in the out years. And then lastly, I'd like to note that to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which would create cost pressure on the fund. The budget office will continue to monitor the board's fund condition statement and keep the line of communication open with the executive staff for any future needs or expectations. Again, thank you for allowing me the opportunity to present at today's meeting, and I'll now be happy to take any questions.
Thank you.
So if I
Member-
read it right, the projected renewal fee revenue is $500,000 less than the budgeted amount. Any explanation for that?
I think I'm going to defer to Suzanne on why we project like that.
So the renewal fee, that it looks like that you have a high-low years. And so in 24-25, it was the low year. And in 25-26, we're going to be experiencing a high year. We are just projecting. So we only have data until August. And we are trying to, when we do our projections, we use the data that we have currently, as well as some data that we have from the previous years. So it is the best estimate, and we try to be conservative and not overestimate or underestimate.
Member Ward.
Well,
I'm sorry.
Can I ask-
Yeah, please go.
Ms. Zuniga, are you concerned about that projection, or you don't think it'll eventuate to be that serious, a reduction in the budget renewal fees?
For the high-low. No, and we do continue to monitor it. We did have a reduction that was concerning in the renewal fees when we had an larger number than anticipated number of retired licenses, but we've seen that drop off and now accounted for that. So not unduly concerning.
So as a follow-up, that was actually going to be my question. Has there been any adjusted analysis? You mentioned that we didn't anticipate the number of retirees. Has there been any adjustment in response to that new information?
It has stabilized. We aren't seeing the same number of people retiring. So we have an idea of what that is. And so that has been built in because we know what that drop off is, because they're no longer renewing active licenses. And then we have since increased, I believe, already the retired license fee to try to address that for the future.
Thank you. Member Ward.
Thanks. My question is, do these numbers include any recent increases that we've made in the renewal fees?
We raised the renewal fee, I would say maybe about 1.5 years ago to $400. So that should be included. Yeah, we do have room. We are not at the statutory cap of our fees. We have room to adjust them by regulation. I'm hoping we don't have to do that anytime soon, but that is their ability to do it.
Okay, so my clarification on that is we passed the possibility to raise the fees, I think is my recollection. So there's room in your
Yeah, so a few years ago, the board adopted regulations to bring us to what at the time was our statutory cap, which is $400 for the renewal fee and the initial fee. In our sunset review bill last year, in the last sunset cycle, we did ask for authority to increase the statutory cap. So it is now higher than that $400. We are charging the $400. We would need to promulgate regulations to go higher. And we would need to justify it, of course, at that time when we need to, but so there is the ability, if we are getting into a concern with the fund condition, to start regulations to increase the fees. We just hopefully won't have to do that anytime soon. We try to be as conservative as possible.
And again, yes, it makes total sense. And I don't have the previous balance sheets in front of me, but when we raised those fees and allowed for the possibility of raising them further, was the 4-year projection more dismal than 0.4%? Like, did we go into the red? Or
The months in
is
reserve.
this better? I guess I'm just a little surprised it's not better.
Okay, Ron says it's worse. I'm not looking at the priors and maybe our budget staff can help, but I will say, just to note, and budget staff can maybe save me from this as well, but what you're seeing here assumes that we spend our entire budget each year, and we do typically revert a healthy amount, and perhaps budgets can chime in as to what we reverted in last year and what our historical reversion is. So that will get factored in each year as we don't spend everything, so that should improve that bottom line.
Thank you.
And to add to that, so in the past few years, it's ranged between 500,000 to about 900,000 reversion. So we are just, like you said, that we are estimating for budget year and ongoing to full appropriation. So any savings that the board is going to have, that is going to be reflected, but at this time, it is at full appropriation.
And I think the big takeaway, if you're looking at sort of solvency, is the stopgap that we have the opportunity, if necessary, to increase fees. And I think that at our last meeting, we discussed the idea that one of the things that the Bureau was doing, or that the department was doing, is holding new hires for a period, so as to basically manage the resources that way as well. Is that still the case?
Do you mean that I was holding hires or the department as a whole?
No.
The board?
Right.
I did do that at LATC before they had their fee increase, and as we were going through some possible restructuring. We haven't really been doing that at the board level. We pretty much filled every position. The board did lose one position, I think earlier this year, effective July 1st, in a sweep that the administration did, a vacant position. So that helps a little bit in terms of what our total personnel costs are, which is obviously the most significant part of our budget. Yeah, but that is something we can look at. There's not a lot of ways that we can reduce costs, but certainly holding positions vacant is one way to do that.
And with the AIT provision, is the anticipated revenue there considered at all?
So that is a good question. We did estimate costs for implementing the architect and training that the governor signed this year. It doesn't take effect until January 1, 2027, so that we can adopt regulations to implement it. We did anticipate ongoing workload and costs from that, that we hoped that we would get funded in the future. At this point, we haven't. So we will need to try again next year because there's a delayed implementation, because we do anticipate ongoing workload from that. And then we will need to determine what the fee will be for that as well. So Tim will work with our budget office as part of the regulations to determine what that fee is. So there will be ongoing revenue from that should cover the costs. Yeah.
Thank you. Any other questions from the board? Moderator, would you please, I'm sorry, I'm going to open up the floor for public comment for those present. Seeing none, I would ask the moderator to open up the virtual panel, virtual portals for any public comment.
Yes, this is the moderator. The instructions are on the screen. If you're logged in and would like to participate in public comment, click on the hand raise icon, typically bottom center of your WebEx screen. If you're calling in, *3 to raise your virtual hand. At this time, I see no request for public comment.
Thank you.
Thank you.
So if I'm correct, our agenda basically takes us into closed session. Or you want to postpone that?
The first item, it will be heard in open session, the petition hearing, and then at that point, the board will need to go into closed session to deliberate on what was presented and requested. And I will maybe turn over.
And I believe that this is being handled by someone online, correct?
Yes.
By the
The
administrative.
parties are going to be participating remotely, yes. And I think the administrative law judge is leading the hearing. Yes,
Okay.
the petition hearing. Mhm.
Thank you. And I'm not sure, I don't have a name as to who that is, so I will basically defer to the moderator to open up the portals for the administrative law judge to take the mantle.
This is the WebEx moderator, Your Honor. I see that you are unmuted.
Good morning.
Good morning, and we can see your video feed as well.
All right. Can everyone hear me?
Yes.
Yes.
All right. My name is Eric Sawyer, E-R-I-C. Last name is Sawyer, S-A-W-Y-E-R. And I'm an administrative law judge with the Office of Administrative Hearings. And I'm in the Los Angeles office. I know the Deputy AG, Ms. Edwards, is with us. Is that so?
Yes, Your Honor. Good morning.
Good morning. Do we have the petitioner with us? Mr. Don or Doan? I don't know if I see him.
I see his email, Your Honor.
His email.
It's well, initials JD, and it states J Society Dwelling or Dweller.
This is the moderator. I will promote J Society Dweller D. I've just promoted you. If we can do a quick mic check.
Yes, can you hear me now? I can see myself, and can you all hear me and see me?
Yes,
I
I
can
can see you and hear you.
Oh, very good. Okay, well, good morning.
Good morning. How do we properly pronounce your last name?
Yeah, it's Don,
Don.
like
Okay.
John, but with a D. Okay.
I figured, but you never know. Thank you.
Thank you, sir.
And Ms. Edwards, as I understand it, we don't have a court reporter, and that's because we're using the WebEx recording as the record?
Exactly.
All right. And just logistically, what we're going to do is we're going to go on the record, and I'll formally identify the case and let both parties identify themselves for the record. Then first, the first step is I'm going to have Ms. Edwards introduce and identify for the record the various documents that have been uploaded on Case Center, basically the petition and all the notice related documents. And if she wants, Ms. Edwards can make a quick overview summary of the discipline process that's happened in this case to date. When she's done, then Mr. Don, I'm going to swear you in. And then if there are any additional comments you'd like to make to the board other than what's in the petition, because I know they've reviewed the petition and we don't need that repeated, but if you have anything that you want to update or supplement or add or just have some general comments you'd like to make to the board, I'll let you do it at that time. Then I'll let Ms. Edwards ask you questions if she has any. And then after that, I'll open it up to the board and see if any of the board members have questions. On that one, President Jones, I'm probably your help because I don't have a great view of the actual in-person hearing room, so I won't know which board members have questions and who they are. So when we get to that point, I'll ask you maybe to recognize a board member by stating their name, and then I'll have that board member tell us who they are for the record, and then they can ask questions, and then we'll go on to the next board member that you recognize. Does that sound workable, Mr. President?
Yes, sir. So noted.
Okay, thank you. All right, so with that being said, once the hearing, once both parties have made a presentation, then we'll do final comments or closing argument. I'll let each of you tell the board what decision you think it should make and why, and then we'll finish with the hearing. As I understand it, once the hearing is over with, the board will meet in closed session, which means everyone will be excused from the room and from the webinar so the board can deliberate confidentially and reach its decision. Mr. Don, I want you to know that there won't be a result on your petition announced today. And the two logical reasons for that are, number one, the board needs to meet after the hearing. So you won't know when the hearing's over with because the board won't have met. But
Yes, sir.
more importantly, the board will be writing a decision, which obviously we can't do today. And the board has 100 days from the end of the hearing to issue that decision. Although I know we all will work hard to issue that well before then.
Yes, sir. Thank you. I appreciate that.
Yeah, yes, of course. I just want to make sure you don't have any expectations that you're going to know today or next week or probably not even next month.
Yes, sir. I understand.
Okay.
No hurries. I'm very patient.
Okay.
Thank you.
Do you have any questions about anything that I've said so far?
No, Your Honor. I'm pretty clear on the proceedings. So yes, I'm good. I have no questions, sir.
Okay. And if any questions do arise, please feel free to raise them. I can't give you legal advice, but I can certainly tell you what we're doing, why we're doing it, etc. Okay.
Yes. Yes, sir. Thank you. Your Honor.
And for everyone, since this is being recorded and we don't have a court reporter, it is important that we handle any names or unusual words or phrases that might have spelling issues. If you could stop and spell that. When we have a court reporter, they're usually good at stopping and saying, how do you spell that? But since this is being recorded, and if a transcript of this recording is requested, someone well after the fact is going to be listening to this and trying to make a transcript. And so it's important that we try to handle spellings now so it's on the record to make the best possible record of this. So that's just a general comment for everyone to keep in mind. If I hear of something like that and step in and interrupt, I apologize in advance. I'm not being rude. I'm probably just asking for information just to make sure the record's clear. So with all that being said, Mr. Don, are you ready to proceed?
Yes, Your Honor.
And Ms. Edwards, are you ready to proceed?
I'm ready.
And Mr. President Jones, is the board ready?
Yes, sir.
Okay, then we are now going on the record. I'm calling the matter of the petition for reduction of penalty that was filed by Jerry Hayes Don. He's the petitioner. This matter is before the California Architects Board, which is within the Department of Consumer Affairs, State of California. The board's case number is A as in Adam, C as in Charlie, 2022-192. And this matter also bears OAH case number 2025-100-045. Today is November 6th, 2025. It is now 10:37 a.m. My name is Eric Sawyer, Administrative Law Judge with the Office of Administrative Hearings, also known as OAH. I'm presiding over the hearing of the petition. I am with a quorum of the board who are meeting in person in Sacramento. However, myself, as well as the petitioner, Mr. Don, and the Deputy Attorney General, who is representing the Attorney General of the state of California, the three of us are participating in this by video conference over the WebEx platform. At this time, I'm going to ask the two parties to identify themselves for the record, beginning with the petitioner. Tell us who you are.
Yes, Your Honor. My name is Jerry Don.
Okay, good morning, Mr. Don.
Good morning, Your Honor.
And you're representing yourself, is that correct?
Yes, sir.
Okay, very well. And representing the Attorney General of California, your appearance, please.
Yes, good morning again, Your Honor. Sharonda Edwards, SHERONDA, Deputy Attorney General for the California Attorney General's Office.
All right, good morning, Ms. Edwards. Just to make clear, Mr. Don, the petition is being decided by the board. You're hearing me speak a lot this morning, and that's because I'm presiding over the hearing and moderating it, as it were, but I'm not voting on this matter. I'm just going to be sitting with the board. So please keep that in mind and direct your comments for the board's consumption, because they are the ones who will be deliberating and deciding this matter after the hearing.
Okay, I understand that.
Okay, so as I mentioned before we actually went on the record, we're going to start and have Ms. Edwards walk us through the documents and provide an overview of the matter before we hear from Mr. Don. So Ms. Edwards, when you're ready, you may proceed.
Thank you, Your Honor. I don't believe that the board here today has a copy from Case Center of the exhibits. These exhibits were uploaded for the benefit of the court, for the attorney, for the administrative law judge. So I will not go into the cases that basically establish the jurisdiction in terms of the request to set and the notice of hearing and so forth. What I will jump into is the petition which the Attorney General's office received by referral from the California Architects Board. So that's Exhibit 1, a petition with attachments from the petitioner, Jerry Hayes Don. Then what I have is the California Architects Board decision and order, which was issued on June 7, 2024, went into effect on July 8th, 2024. And before I get into that particular decision, I'd like to mention the accusation that was filed on February 22nd, 2024, accusation number AC 2022-192. There are several allegations here. One moment, please. The first allegation is violation of the written contract provisions of the Architects Practice Act. The second cause for discipline is willful misconduct. The third cause for discipline is signing others' plans or instruments. The fourth cause for discipline is aiding and abetting unlicensed individual and that individual's company. And then the last or fifth cause for discipline is a lack of informed consent. So pursuant to the decision and order, the parties entered into a stipulated settlement agreement, which was adopted by the board. And as I stated previously, went into effect on July 8th, 2024. We have hard admissions from the respondent with respect to the 5 causes for discipline. And we have a revocation, then a revocation stayed. The petitioner was placed on probation for a period of 5 years, subject to terms and conditions. One of which, and I'll just mention the salient ones. The first one was actual suspension for a period of 30 days. Continuing education courses and cost reimbursement of $11,167.50. And then I also have the licensing history of the petitioner. He first became licensed as an architect on December 22nd, 1990, and he currently has an expiration date of his license has an expiration date of February 28, 2027, unless it's renewed. And that sums up the exhibits in this matter, Your Honor.
Thank you, Ms. Edwards. For the record, I'm marking for identification as Exhibit 1, the petition that Mr. Don filed. Ms. Edwards, any objection to Exhibit 1 being admitted?
No objection.
All right, Exhibit 1's admitted. I'm marking for identification as Exhibit 8, the board's prior decision and order in this matter, which put Mr. Don's license on probation. Mr. Don, do you have any objection to my admitting that document as Exhibit 8?
No, Your Honor.
All right, it's so admitted. I'm marking for identification as Exhibit 9, the accusation that Ms. Edwards referred to. It's the operative pleading that put into motion the discipline that we're here discussing today. Mr. Don, any objection to Exhibit 9 being admitted?
No, Your Honor.
All right, Exhibit 9's admitted. I'm marking for identification as Exhibit 10, the board's certification of license history for Mr. Don, just indicating the board's statement of his licensing history. Mr. Don, any objection to my admitting Exhibit 10?
No, Your Honor.
All right, Exhibit 10 is admitted. And finally, for jurisdictional purposes only, I'm marking for identification as Exhibit 3 the notice of assigned hearing date. As Exhibit 4, the request for change of venue and advancement of the hearing date. As Exhibit 5, the Attorney General's supplemental request for change of venue. As Exhibit 6, OAH's order granting change of hearing date and location. And Exhibit 7, the amended notice of hearing, which provided Mr. Don with notice of today's date, time, and mode of hearing. Mr. Don, I'm marking these just so the record's clear that basically you were given notice of today's proceeding and that you elected to appear by video conference and have this hearing recorded over the WebEx platform as opposed to appearing in person and having a court reporter. Do you understand that?
Yes, Your Honor, I do.
Do you have any objection to my admitting any of those documents I just described for that limited purpose of establishing jurisdiction?
I do not, Your Honor.
Okay, then I will admit for that limited purpose of establishing jurisdiction, Exhibits 3, 4, 5, 6, and 7. Ms. Edwards, is there anything else you'd like to say?
Not at this time, other than, of course, as we all know, the petitioner has the burden of proof, which is clear and convincing evidence to a reasonable certainty.
Okay, thank you, Ms. Edwards. All right, then, Mr. Don, I'm going to give you now an opportunity to make a presentation to the board. So what I would like to do is place you under oath first. So would you please raise your right hand? Do you swear or affirm under penalty of perjury under the laws of the state of California that in this hearing you'll tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
And for the record, please state and spell your name.
It's Jerry Hayes Don, Jerry Hayes Don.
Thank you, Mr. Don. What would you like the board to know about your petition and your situation?
Well, thank you, Your Honor. I appreciate the opportunity to be here today with the board hearing my case. And I think this whole complaint. Let me kind of back up. I was hired years ago by Southwest Concepts to be a staff architect because most of the projects they did were all custom residential work, and every HOA required an architect stamp on the plans. And so I was hired to be the staff architect that would review plans, make sure everything is in order, as required by the HOA and the building department, plan check corrections, and then I would stamp and approve the plans to go out. I was not hired to be a project architect or a production personnel or design or anything. All that was handled by the company owner and his family. It was a family-run business. His sons did all the design drafting work, and I would come in every week. If they had anything to go over, we'd sit at the conference table or look on the computer screen, and I would just oversee the work. Yep, looks pretty good. Or, talk things over and make sure everything was proper, and that was pretty much the scope of my work. And they would do some little commercial tenant improvements, some small multifamily housing projects, but most of all, I was basically on their website as a staff architect, and I guess you'd just call it window dressing to give clients peace of mind that they're not going to have to go shopping for an architect and all that. And so that was my limited scope of duties. I really had no say-so over design issues or anything, but I would make sure that any commercial work had occupancy exiting and all these things, you know, covered. Over the years, um, 5, 6 years ago, I was really having problems with my knees. I was hurt I was in Vietnam War in the U.S. Navy, and I was hurt on the flight deck of an aircraft carrier, injured my legs pretty good. And over the years, ended up about 5 years ago getting both knees replaced. And then a year and a half ago, I had to get my left hip replaced. And in the middle of all this, um, I was told I was exposed to Agent Orange in Vietnam. And then over 3 years ago, I was diagnosed with fibrous lymphoma cancer. And so I had to go through surgeries, rehabs, hospitals, lengthy 2.5 years of chemotherapy for all this. And a lot of that kept me out of the office, away from my duties and responsibilities in there. And at no time did they ever misuse my license. They're very honest. It's a very honest company. And so I was not able at times to be in to go over stuff, but I trusted them, and, you know, we never had any problems at all. And I think what initiated this whole complaint was a project that came in. Um, it was a marijuana growing facility that this man brought in. And Steve and I, the owner, Steve and Mr. Nieto, we looked at these plans, every single page. We went over it in great depth and detail. And it was done professionally by another firm. And all we were asked to do would be to finish the plan check and get him his permits. And that was pretty much it. And I never did meet the man. I wouldn't know him if I ran into him at Starbucks. But so during the course of this project, there was some extra work that was not included in the contract, which the client was subsequently billed for. And so that caused a big, huge dispute over the invoice. And apparently the client sued Mr. Nieto in court, and lost, because the contract was clear and he owed the money. And so I believe that to retaliate on Steve, he complained about me, that I'm just aiding and abetting and just randomly, willy-nilly signing stuff off for a cheap buck. And that is not the case. Mr. Nieto is a very fair man, and we have worked together for many years. I used to do AutoCAD drafting for him many years ago, and we've had a long-term, good, wonderful relationship up there. And so when this whole case came to a peak, and I was getting the letters from the Attorney General's office, I was rehabbing from knee and hip surgery. I'm in the middle of chemotherapy, which I was going in once a month for 4 days straight, getting intense chemo cancer therapy. And at that time, I was just in a medical lost in space state of mind and body. And for me to have to respond to all this, it was just completely overwhelming. I couldn't grasp, I couldn't even think about it. It was making me sick to my stomach. And so I just opted for the stipulated settlement, and I just wanted to get this over and done with, because I could not handle the stress. My doctor has just told me over and over again, you got to minimize the stress in your life, because it will aggravate your cancer, and you have to have your body relaxed. Your peace of mind is more important than anything. So I quit my job up there with the company and just pretty much pleading no contest, wave the white flag, whatever it is, I will do whatever you want from me. And so that was they accepted the stipulated settlement. And I had asked, well, because I've been licensed for 30 plus years and I've never had one complaint filed on me for the whole time. My record is as clean, as pure as the wind-driven snow. And so I asked them if I could, instead of a 90-day suspension, if they would grant 30 days. And then I asked about, instead of 5 years, how about 1? And so they agreed to the 30-day suspension. But they said I could appeal after 1 year. And so we passed that 1 year mark, and I did submit my petition, and I did abide by all of the requirements of continuing education. I got that done right away. The cost that was due to be reimbursed, I sent all that money paid in full right away. I've maintained my quarterly reports were filled out and sent in as required when due. And my last quarterly report, I had nothing to report. The previous quarterly report, I only had one job that I finished up. And because of my ongoing medical issues, I've turned away work. I'm not working anymore just because I just can't do it. And so also too, another thing that I'm facing right now is that next month I have a biopsy scheduled for prostate cancer. And pending the outcome of that pathology report, I may be facing prostate cancer. I won't know until probably January. So that's what's on my plate right now. And so I have no work going on, as I'm just pretty much existing, living on Social Security and my VA disability pension. And I'm also a licensed real estate agent, but I cannot renew my real estate license, which is expired. My broker won't sign off for me until this case is completed. So once I get the completion paperwork of this disciplinary action, then I can send it to my broker and he'll approve me to renew my real estate license. But again, on my real estate career, last year I transitioned my license to a referral only status in order to save all the realtor association dues and fees and everything. And referral just means if I can refer a client to another agent, and then I would get a referral fee on that transaction. But I don't have any access to the MLS, and I can't do full-time real estate duties. And also too, my medical problems kept me out of doing that 2 years ago. I just couldn't do it anymore. And so that's kind of where we're at right now with all that. And gosh, let me think what else. Yeah, I've made the few little jobs that I've done. I have put together a whole brand new contract, which one of the ladies, Stephanie, I can't remember her name. I sent copies of my new contract into here to review to make sure it met all requirements of the Business and Professions Code, and any little jobs that I've been taking on, it's completely lined out where I have complete control from the beginning to the very end. Everything gets reviewed, approved, commented, and any corrections made noted, and just to make sure that there is no misunderstanding of what I'm doing and what they're getting from me and what I'm doing for them. And I have just made it a point my whole life and my whole career to be ethical and honest and treat customers fairly. I'm not in this for the money. I'm in this to be of service and to help people. And it's just really sad that I got dragged into the board here with this complaint from this gentleman, and I feel like his dispute with Mr. Nieto was like two whales fighting over a big fish, and I'm a little shrimp in between them getting crunched. And it's just it's just an unfortunate. If he would have come to me at the very beginning and said, "Hey, what's going on?" He would have got to know me. We could have made friends, go out for lunch, talk about whatever it is, so he would understand what my role is over there and how I work for Mr. Nieto. But we never had that opportunity, and I just feel really bad that this whole case has been an enormous amount of work on the state, on the architect's board, the attorney general's office, and the amount of money that's being spent on all this is just, it's just ridiculous. But it's out of my hands, and my gosh, I just can't think of anything else to add, Your Honor. I think that's pretty much all I have to say right now. So thank you for letting me speak. Appreciate it.
Thank you, Mr. Don. As I mentioned before, I'm going to see if Ms. Edwards has any questions for you.
Yes, Your Honor.
Ms. Edwards?
Oh, I'm sorry, I was on mute. My apologies. Good morning, Mr. Don. I just have a couple of questions. And, my role here as the Deputy Attorney General is pretty much public protection. And so that's the reason I'm here today. I heard you recite the facts of the case, and I just want to make sure that we're clear on it, because we're not here to relitigate the case, okay? But you mentioned something to the effect of a no contest. And no contest is when you don't admit it, the allegations. But here you did through hard admissions. And you talked about a contract dispute when, in fact, on June 1st, 2021, you used your architectural stamp and rubber stamp plans created by a third party. And that was for 100 Mile House, which was a conversion of a warehouse building into a cannabis cultivation plant. And that was in Cathedral City. And you did this when you had no affiliation with 100 Mile House, and you were employed with Southwest Concepts. So again, you rubber stamped some plans by a third party. I just want to make sure that that's clear and you're not minimizing, because I didn't hear you say anything about you rubber stamping somebody else's plans that you did not create or prepare. What's your response to that?
Well, no, as I said, the client brought these plans in that were prepared by another professional company, and I believe Steve put Southwest, converted them into his drawings, and completed the plan check and got their permits approved. And of course, I put my stamp on them, and just thought it was just a normal part of the process of getting the plans approved and permitted. Even though they were drafted and prepared by another company, their names did not appear on the drawings.
Okay, and you understand today that that's not permitted for you to rubber stamp somebody else's plans?
Well, I did not understand that. I did not know that was not allowed back in the day. I just thought it was acceptable to do that.
Okay, and then I'll move on to my second and last question. Looking at your petition packet, I was looking at your letters of support. One moment, I'm scrolling. You have two letters of support. One is by an architect, and I did look up that architect, and that's Roy, R-O-Y, middle initial A, Asaro, ASARO, of Architect Incorporated. And so did you explain to that particular colleague the nature of your accusation? Did you show him the accusation before he prepared this letter so that he would know exactly what
Well, yeah, I
you were
told
accused
them
of?
they all know what the charges were. And, you know, I've known Mr. Acero. We were in the Navy together when we were 20 years old, and we've been associates and best friends ever since. And Mr. Chandy, I've known him for several years, and he's a great friend and a client and a customer. And I told him what was going on from when this all happened. And so they all know, and um, they have full faith in me. I'm not a dishonest, you know, stamp it off for cheap for $100 architect. I don't do that. And so, you know, they wrote me beautiful letters of support, and for that I'm really very thankful. I wish I could have them as character witnesses today, but they're neither one of them are available to make the hearing. But I would definitely use their letters of support as my character witnesses for today.
Okay, and for the record, with respect to your second letter, and you made reference to Mr. Shandy, his full name is, I will spell it, Nacha, excuse me, Nachhattar, middle name Singh, Singh, last name Shandy, Chandi. And you said that person is a friend and a former client? Is that what you said?
Yes.
Okay.
Yeah, I've worked for him on little jobs here and there. He's asked me to help to go pull permits for him on little things, and he's a big big developer in India. He develops shopping centers and gas stations, fast food, hotels, and he's a very wonderful man and one of my best clients ever.
Okay, so I'm looking at the second paragraph, second sentence, quote, despite the unfortunate circumstances that led to his probation stemming not from professional misconduct, but from a billing dispute between his former employer and a dissatisfied client, unquote. So again, here it's saying it wasn't professional misconduct, but just like a contractual billing dispute. So that's why I wanted to know whether he was actually aware of the allegations and the accusation.
Yeah.
Okay.
Yeah, he was aware. I told Mr. Chandy and Mr. Acero. I explained about the billing dispute between Mr. Nieto and the client, and the battle. It was just a big, you know, a big battle that they were having, and the client sued Mr. Nieto for the bill and lost because the services were clearly not included in the scope of services of the original contract. So they all knew, and they all know that he complained on me after after he lost the fight, just to retaliate on me, punish me for their billing dispute. So
Okay, and then lastly, so we talked about earlier, I mentioned the costs recovery. Have you been able to pay that in full?
yes, I paid it right away as soon as we got the terms of the stipulated settlement. I went to the bank and got money orders out, and Mr. Nieto sent everything in as required.
And have you taken an ethics course?
Yes, I did.
Okay.
I took the ethics class online, and I think that was through the AIA AEC Knowledge or something. I can't remember exactly the website that I did that right away.
Okay, and when you say right away, when was the date of completion?
Pardon me, say again?
When did you take the course?
I believe it was with AEC Knowledge, or oh, I can't remember. It was one of the online things. I think it was through the AIA website, but I can't remember specifically. But I did take it and send in the proof that I completed the ethics training class to the enforcement people at the board.
Okay. Thank you, Mr. Don. No further questions.
Thank you, Ms. Edwards.
Thank you, Ms. Edwards. Now we'll open it up to the board and see if any members have any questions they'd like to ask Mr. Don. And President Jones, if you could recognize one member at a time and tell us who that person is. And then when the person starts asking questions, if they could first identify themselves for the record by stating and spelling their name.
Thank you, Your Honor. The chair will recognize any. You have a question or comment? Yeah. Member Ward.
This is Member Ward. Yes, I do just have a few as we deliberate. I think it would be nicer to have some clarity on a couple of points. One for Council Edwards. I see that that Mr. Don has signed. There's the accusation list of I think 5 different accusations that was signed. So I just wanted to be clear that at some point that was sent to him. He agreed to those and signed it. What would have happened had he not signed that?
You said the accusation with respect to the allegations. Are you talking about the stipulated settlement?
Yes, I'm sorry, stipulated settlement.
Okay. Had there not been a resolution by a stipulated settlement agreement, we would have gone to hearing, an administrative hearing, an evidentiary hearing before the Office of Administrative Hearings. I would have put on all of the documentary evidence and also had some witnesses testify, particularly the reporting party with respect to the transactions. And then, of course, it would have been, respondent, whether he was self-represented or if he had retained an attorney, be able to put on his case in chief, his evidence. And then ultimately we do our closing arguments, and then the case would be under submission before the administrative law judge to issue a proposed decision within 30 days of submission of all of the evidence.
Okay, great. Thank you so much. And I have one more question for Your Honor Sawyer. In the testimony today, I thought I was hearing maybe that there was an agreement to the citations at a time when he was under duress. Are we able to take that into consideration, or is the fact that the documents basically say that there was a settlement, he signed, he agreed, and that we're just simply here today to respond to the request for a shortened probation? Is that the only thing up for discussion today?
All right, Board Member Ward, we can discuss that when you're in deliberation. Let me be clear that right now, the only thing we're doing right now is if anyone has any questions for Mr. Don.
So I guess that's my question. I couldn't tell if he was alluding to that in his testimony today. Was he?
I'm sorry to interrupt you, but Michael Connotes, legal counsel, I think we're getting into potential deliberations here. This is an opportunity for board members to ask direct questions to the witness himself. So I think we should probably save this type of discussion for the closed session period when we talk to the ALJ.
Okay.
All right, just one thought, Member Ward. If you would like to ask Mr. Don a question about that, you're free to do that right now. That's what we're doing right now. So did you want to ask him about that?
Sure. Mr. Don, thank you so much for all the time and the accurate, or not accurate, but the detailed explanation. For me, I just had the question, were you trying to say that, or do you still stand by your, I mean, you signed it. Did you sign the, what are they called again? I'm sorry, counsel. The stipulation. Did you sign the stipulation, and did you mean it?
Yes, I did.
Okay, thank
Yes,
you. That's
sir.
all I needed. Thank you.
All right, thank you. Member Ward. President Jones, are there any other board members that have questions for Mr. Don?
Yes, Your Honor. Member Brash.
Hi, yes, I have a quick question regarding when you were working with SW as a staff architect. When you stamped the drawings, were you employed by them or was it a project contract base for your work?
No, I was a salaried employee. I was on a salary of $500 a week on an ongoing basis, and they, paid taxes, Social Security, and all that, and so I was not on a job by job contract basis at all. It was just to be the staff architect, just to oversee stuff as it went in and out the door. We were just basically a permit getting service, and people come in, they just wanted a set of plans and a building permit, and that's pretty much what we did. So I was there just to expedite and help along the process. I wasn't, like I said before, I wasn't a design architect. I wasn't a project manager. I had no say-so whatsoever with any clients, contracts, or anything. I was just, just there to, move the project along and get it to a happy conclusion and permits issued.
I have one more follow-up question, if that's okay. The contract that we were talking about, was that between yourself and the third party, or was it between yourself and the company that?
It was between Southwest Concepts and the client.
Okay,
I was not involved. I had nothing to do with the contract terms or anything. I don't even know how much they charged them. I was not privy or involved in any of that.
Thank you. That's all my questions.
Thank you.
Okay, thank you, Board Member Brash. President Jones, are there any other members that have questions?
I don't see any, but Your Honor, I do have a series of questions if you would indulge me. So
Please.
To Mr. Don, do you understand the terms and the requirements for the term responsible control?
Yes, responsible control for me means overseeing the preparation of plans, commenting, reviewing, and approving them, and going through any plan check correction lists or concerns of the client to make sure that the clients are getting what they want and that the plans meet community standards for issuing building permits and for the construction thereof.
Thank you. And then secondly, you mentioned earlier that your employer, the sons of your employer were the drafts people on the project. Were they employees of the company as well?
Yes, sir. Yeah, they were all the employees. Two sons were, the project, job captains and did all the work. The dad, Steve, was the big boss in there. He was the shot caller. He had full control over everything, and his wife was the bookkeeper and office manager. And it was just a family-run business. They're all very creative people. They've done some beautiful high-end luxury residential work in every high-end residential community out here in the Coachella Valley, and it was just great to be a part of that. Their stuff is really extremely beautiful work, and but they did it all. I was not a participant in any of the design or drafting of the plans, so that was.
But you were responsible for overseeing and validating the quality of the work that was produced.
Yes, sir. Yeah, I had to make sure that it was all, the community standards is important to me. I've been doing this for a very long time, and I have graphic standards. I have things that I want to see on the plans, how the drawings are done, what information is on what drawing, and how it looks on paper. And they were very conscientious of producing a very clean set of plans, and I was very proud of the work that they produced there, and was just blessed to be a part of it.
Thank you very much.
Thank you, sir.
Your Honor, I think I'd like to turn the floor back to Board Member Ward, please.
I just have one more question, Mr. Don, for Mr. Don. Did I hear during your testimony that you said that there was the time where you couldn't come into the office and that you allowed the company to use your stamp? I'm assuming, there's a follow-up to that, but did I hear that correctly?
Yeah, there was sometimes when I couldn't come in, I'm in the hospital and, I spent a lot of time in the hospital after my knee replacement, even more time after my hip replacement. And I think there was a couple little jobs that went in and out the door that I did not get to personally review. And, I was okay with that because these guys are honest as well. They're not going to use my license inappropriately, and I had full faith that they were guarding my license and being honest and straightforward.
Okay, that's clear. What about your signature on your stamp? How was the signature?
It was electronic. I had stamped my stamp and signature on a piece of white paper, and then they scanned it, and then they would
Okay.
Reproduce it on their title block.
So I'm assuming that's why you signed that during that time, it was impossible for you to have responsible control over the drawings due to your health.
Yes, sir.
Okay, thank you.
Thank you.
Just as a follow-up, again, this is Member Jones. As a follow-up to that question, the title block itself bore the name of who and what organization?
Yes, Southwest Concepts Incorporated.
Thank you.
Mm-hmm.
Your Honor, I believe that's all the questions that the board has.
Okay, thank you, President Jones. Mr. Don, you've been asked questions by Ms. Edwards and by various board members. Have any of those questions triggered any other information you'd like the board to know?
Oh gosh, I can't think of anything. I appreciate everybody's questions and hearing my answers, and I just really appreciate everybody's attention to this matter, and I'm just grateful for and thankful for everybody's considering my appeal here. Thank you, sir. Thank you, Your Honor.
Thank you, Mr. Don. So now we'll move into the final phase of the hearing, which are the closing thoughts. I'm going to let Ms. Edwards lead us off if she has any overview or summaries or recommendations for the board on behalf of the Attorney General's office. And then since you have the burden of proof, Mr. Don, I'll give you the final word. So,
yes,
Ms. Edwards, is there a summary that you would like to offer the board at the in closing here?
I really don't have a closing argument, anything of that nature. I just have, for the people of the state of California, I just have a concern regarding the rubber stamping, and it just doesn't seem clear to me that Mr. Don understands that that is not permitted. And it just rings to me that this company that was not licensed was basically renting his stamp, and they had access to his electronic signature. And so that's just concerning. That just seems to be an element of fraud. And so I do appreciate that Mr. Don has been licensed for 30 years, and this is the first time he's been before the board in a disciplinary manner. But I'm on the fence with respect to rehabilitation, with respect to the original allegation with that I submit.
Thank you, Ms. Edwards. And Mr. Don, do you have any final comments you'd like to make to the board?
Yes, Your Honor. Thank you. Well, ladies and gentlemen of the board, I really appreciate your attention to this matter here. And, we live in an imperfect world. And for me to sit there with my inked stamp and stamp off 50 sheets of 3 or 4 different sets would be a lot of work. and I'd get an arm ache in my hand from having to stamp and sign off every page. And so I think it's pretty common practice these days for an electronic reproduction of the stamp and signature. It's certainly allowed by every building department we deal with, and I don't think there's any fraud involved in this at all. It's a straight up service work for me to be a part of the process and oversee the things going out the door, meet my standards as well as the standards of the building department and the construction industry in general. So um, I just lay my case at the feet of the board and pray for the wisdom of Solomon in judging my case. And I just thank you so much for the opportunity to be here today. Thank you, Your Honor.
Thank you, Mr. Don. As I mentioned before, after the hearing, the board will meet in executive session to deliberate on this matter. The board has 100 days from today to issue its decision, but as I mentioned before, the board will endeavor to act upon that much faster than that. So with all this being said, the matter is submitted and we're now going to go off the record.
Yes, Your Honor. Thank you so much.
All right, thank you. And President Jones, you have the microphone back.
Thank you, Your Honor. We will now go into closed session, and I will ask that the moderator suspend recording and would ask the audience public to excuse themselves. And for those who intend to return, we will basically notify you when we've completed our task. We're all set. Moderator, can I have you confirm that the portals for the public is open, please?
This is the moderator. Yes, it is unlocked. We do have attendees online, and I'm ready to go in from my end.
Thank you very much. Welcome back. We will now advance the agenda. We go to agenda item G, and which is basically a discussion around artificial intelligence. Just some housekeeping. As you guys know, I've been talking about this for a while. It's one of my hidden interests, but I probably invest way more of my time in this than my partners want me to in my practice. But one of the things that I've talked about before is how does artificial intelligence, or what's the potential benefits and risks of artificial intelligence to the practice of architecture, and for us specifically, how it impacts or serves the public interest. So one of the things that I did, I sought out those agencies that have already engaged this conversation, and I was directed to the Department of Motor Vehicles. So we have with us today Brian Souble. Thank you, sir. I had to confirm the pronunciation. Brian was as a retired chief deputy director and chief counsel for the California Department of Motor Vehicles, but he basically led their charge in the area of artificial intelligence and how they navigated the evolution of autonomous vehicles, all of which we are extremely familiar with in the way of Cruise and Waymo and the others. So Brian has basically agreed to come to us today and kind of share with us some of his experiences and how we might basically prepare ourselves in our thinking about what we might be looking for as we seek to regulate the practice of architecture with artificial intelligence in mind. And I'll turn the floor to Brian.
Good afternoon. Thank you, Chair Jones and members of the board. As he introduced, I am Brian Souble. I'm a retired deputy director and general counsel from the Department of Motor Vehicles. I retired from DMV about 5 years ago, and then jumped right back in and went in as the acting general counsel for the newly formed state privacy protection agency. So I come at it from two aspects of regulating the advent of emerging technologies and how we as regulatory bodies can deal with them. As Chair Jones mentioned, DMV was charged by legislation in 2012 with regulating the new industry of self-driving autonomous vehicles. The statute was enacted as a result of Assembly Bill 1298 in 2012. Even having a background of the process of a statute forming to put that requirement on DMV, unfortunately, it was first going to be foisted upon the Highway Patrol, and they backed out of it. We got stuck with it. And with that, you have an agency with no technological background being charged with regulating what is at the time viewed as the future of public transportation. And not only public transportation, but personal transportation and its impacts on actually the workforce and the economy. You know, at the time you had outfits like Uber losing billions of dollars a quarter based on costs. And what the future held was that a lot of their costs go down and profits go up when the cars drive themselves. So with that in mind, when we were formed with that task, you, as a state agency, there are overlapping responsibilities. You know, it's just, DMV itself doesn't regulate the safety of a car. That is under federal law, that's the responsibility of the National Highway Traffic Safety Administration. Our statute had the fallacy of making us form a regulation that required the industry to certify that their vehicles met federal standards for autonomous vehicles. In 2012, there were no federal standards for autonomous vehicles. Guess what? Today, there still are no federal standards for autonomous vehicles. So you're charged with a regulatory regime that has you get a certification for something that does not exist. And so that required DMV to kind of think outside the box. And how did we do that? The other thought process was that there are other state agencies and other local agencies that are involved with the regulation of this technology. And so immediately the department formed a statewide steering committee, and that involved getting the Highway Patrol, Caltrans, the Public Utilities Commission, as well as some local jurisdictions involved in the process of drafting a regulation to tackle that task. One thing that everyone forgets is that people think that regulations are quick to do. As your lawyer will probably tell you, they're not. Because you have a process that's built with 45 days at the beginning and 45 days at the end. And when you're tasked with giving a year to do something, you already have 3 months are already gone. So that required DMV to actually try and find the expertise that could help us deal with the technical challenge. What I would encourage anyone to do that is faced with that is rely on your stakeholders. We stumbled upon trying to create standards that we thought were based on auto safety standards and would say things like, to make sure, to assure us that your vehicles are safe, give us your functional safety plan. And then in a meeting with one company developing the technology, you've seen their cars all over San Francisco. They said, yeah, cars that safety equipment is developed 10 years ahead of time. And if you ask for this, we're going to give you a conference room full of binders, and who's going to read them? And who is in-house has that expertise? At DMV, there was one engineer in the entire 10,000 workforce, and he was an aerospace engineer. So we did not have the internal expertise to deal with the technological challenge. What we were encouraged to do, and what we did, was relied on that. UC Berkeley has a transportation institute. They were already doing research in autonomous technology for large vehicles. So they became our technical experts. We don't have expertise on what law enforcement may require. So part of our drafting process was working with the Highway Patrol to come up with that. That collaboration was really essential in coming up, for me as the draftsman of the regulations, coming up with what the necessary requirements would be. Since DMV can't dictate, what the technical requirements are for the safety of a vehicle, we had to try and think of how, as a regulator, what is the realm of our authority? We license safe drivers. The feds license safe vehicles, and we were reminded over and over again not to overstep that. And that became important when you think of things like regulating what you're tasked to do, which is permitting the advance of the technology, as opposed to regulating and prescribing a specific way to get there. And what I mean by that is we had to avoid prescribing, this is the technology that you have to have on the vehicle. That's not our universe. So we saw different approaches. If you see a Waymo car, it's got the spinning LiDAR, it's got radar, it's got sonar, and it's got all this equipment. Tesla had a different process. They wanted to use cameras. As a regulator, you're balancing public safety, your consumer safety versus advancing the technology and not impeding what the developers like to call the positive disruption. And then there's the concept of fitting around, a square peg into a round hole. Many of our laws that regulate the entities that were responsible for regulating were drafted years ago without a concept of what advancing technology would be. And I think that's why it got pushed onto the regulator to try and come up with it without having to change statutes. How do we do it? Since we can't dictate the equipment of the vehicle, the approach that DMV took was regulating what came to it. And so it had a certification process built into regulations, almost like if you want to drive a car, you have to have a driver's license. If you want to put the technology on the street, you have to have a permit that came from DMV. Throughout the process, people contemplated things like treat the technology like you would treat a human. Well, how would DMV treat the technology like a human? When you're 16 years old, you get your permit, and then you go into DMV for your license, you take a drive test. So you get a lot of suggestions. Well, we'll just bring the car in and you'll take it on a drive test. That wouldn't work because the DMV drive test is simple. You take you on a simple route, and it's a graduated level of watching you. How do you do that with a technology? There wasn't an idea. You don't know what you don't know. And so we steered away from that and looked more of having the developers of the technology provide certain certifications to you as an agency that fits within your capacity to regulate. You're going to certify that the vehicle obeys traffic laws. You're going to set up a process where information has to be provided to law enforcement. How do you turn the vehicle off if there's a problem? And then how do you police that? In the regulatory process that I envisioned, it's the punishment on the permit that you give them to have the vehicles on the street. So if a vehicle isn't obeying traffic laws, what is me as an oversight agency? What is my authority to do something about that? Well, the discipline becomes onto the manufacturer of that process. That then starts linking in all of the legal concepts, like what happens if a car gets in a crash? Who's going to be responsible for things like that? We took, and I don't know if it's an arrogant approach, but we took the approach that we're here in California, the home of innovation. We've got a very tech-savvy federal district court in San Francisco. So if there's any place to try this stuff out, here in Northern California is the place to be. So with that, we kept in mind that we're the right place to start doing the regulation. I mentioned in the past, you don't know what you don't know. And even though you set up these requirements, we've seen problems still with the system that I set up. We started reading things like the vehicles in San Francisco didn't get out of the way of a fire truck. Or as Chairman Jones mentioned, he mentioned the name of Cruise Automation, which doesn't have vehicles testing anymore. And I'm going to use that as an example. We drafted a regulation that contemplated that if something goes wrong, the vehicle should, using the industry term, come to a safe operating position. So it should do a safe maneuver after something happens. What happened in the Cruise accident? A car in front of it hit a pedestrian. Actually, the vehicle did what it was supposed to do, which was pull over and get out of the way. What was unintended and what we could never contemplate, there was a person stuck under the vehicle when it did what it was designed to do. So I use that as an example that even as you regulate, there are things you will never think of that will happen. And you have to keep that in mind. And you have to keep the flexibility in mind that your regulation isn't static. You as a regulator have to be willing put all of this time in. I started working on regulations when the legislation was passed in 2012. They went into effect in 2014. When I retired in 2020, we were still working on them, and they're still not done. So you have to have the idea that no matter what you do, you're not really done, because as the technology evolves, so does your ability to regulate it and to deal with it and to have the oversight of it. One of the things that I, really like to point out is you can't overregulate. You have to stick to what your regulatory task is. There becomes intercompeting interests. As an anecdote, when I was general counsel for the Privacy Protection Agency, one of our board members left, and he became the chief of staff to the newly elected mayor of Los Angeles. And legislation passed to allow the vehicles to operate in Los Angeles. And I get a call from him. Can you talk to the mayor's council? Because we don't know who to deal with. Because while DMV permits the cars, the PUC permits it as a riding company. And if we have concerns, who do we talk to? And I use that as an example of you have to have, as a regulator, a relationship with your sister agencies that are tasked with that, because you can get into a process where you're trying to move forward with one objective that is inconsistent with what your sister agency wants to do. So that collaboration was very important. Again, and I can't stress enough the fact that we as regulatory bodies don't have the technical knowledge that comes to us from out of the Silicon Valley and out of these innovators who are trying to, and the idea is that, hey, we're doing things that, while it's a disruption, it's for the positive. And that balance that I mentioned, balancing consumer protection, fostering innovation, that comes head up against the political will when you have a situation that there's something wrong with the technology. There was a reluctance to actually take disciplinary action against companies, because when you do that, you may be affecting the economy that's coming out of the Silicon Valley. So it took something drastic, like a person being dragged 20 feet under the car, before DMV actually took that really drastic step of suspending a company's permit. And that has to deal with like the political will to do something. I'll use another example. Back in 2015, Uber had merged, had recruited, so to speak, an engineer that was working on the technology for Google. And they started, and they had their vehicles in San Francisco, and they launched them. And I actually went down to a meeting in San Francisco and saw their cars. And it was kind of like that old Supreme Court thing. I can't tell you what pornography is, but I know it when I see it. I sat in their car and I said, I can't tell you if this is an autonomous car, but I've ridden in ones that people say are autonomous, and this one seems to do that. Well, they put them on the streets anyway. And what do we do in response? Well, we had set up a regime where to put your car on the street, you had to have a permit from DMV. DMV was going to put a mark on the title of that vehicle. The thought process was, if you add things to a car and then you take it off, the manufacturer won't warrant it. So it's not safe to be sold to the public. So we're going to tag the cars. Well, when Uber didn't get that permit from us, we didn't title their vehicles correctly. So I canceled the titles of their vehicles. And they put them on trucks and they sent them off to Phoenix. And so the reason why I bring out that example is, yes, even though you may not think you have authority, sometimes you have to get and think within the limited authority that you have. What can you do when the unexpected happens, and how can you be flexible enough to address it? So I think that, and then one last issue that I always focus on, because I worked as a general counsel at the privacy agency, just think about your car and how much it knows about what you do and where you go and when you do it and where you go. We used to joke that you're driving from DMV headquarters to the Sacramento airport, and your car happens to know that you love Taco Bell. How many times is it going to stop you at Taco Bell on the way to the airport? Because it knows what you do and it knows when you do it. Well, how do you protect the privacy of that data through a regulatory process, since they need that data in order to map the streets for the vehicle to operate safely? We came up with a process that you have to certify that you're anonymizing any data that the cars collect. So you can't monetize it. You can't sell that data to the gas stations that you use or the grocery stores that you shop at. So you have to at least think in the realm of can I protect the information that the consumer is providing to the vehicle, while at the same time not impeding its safe operation on the public streets. I leave it with that. Again, it is a process that is not static. Once you get charged with regulating and overseeing a technology, you have to have the flexibility of growing with it. You know, in 2013, we thought that when I say we, I'm thinking DMV and the industry. You started seeing projections. Mercedes said we'll have a car on the streets that drives by itself by 2019. And then everybody jumped on it. We'll have a car on the streets that drives by itself by 2017. Still don't have that because there's always the edge cases that they just haven't solved yet. They don't have true artificial intelligence that are driving vehicles yet. And until we get there, you know, we're not going to see those vehicles. We're always going to be at a point of having to have a driver behind the wheel with their hands on it. We see the examples in San Francisco. Waymo is going through problems. You know, the big press this week is it ran over a cat last week, and now there's a cry to have locals get into regulating. So what I would charge you with is that you have to look at not only when you're regulating from your statewide concern, you will get the calls that something's going to happen. And then someone's going to want to impede on your regulatory authority by adding their own requirements. And then you get into that argument, who has a superior jurisdiction over it. So with that, I'll open it to any questions you may have for me and anything about my experiences in developing regulations, as well as some of the edge cases that happened as we were doing that.
Excellent. Thank you very much. Are there any questions or comments from the board? Juan.
I just want to say thank you so much. This is very, very educational, and it will definitely prepare us much better as we look into AI for architectural profession. Thank you.
You're welcome.
Robert? Oh. First, I love the TV show. Congratulations. I appreciate the thought about privacy because it's not as maybe dangerous here, but now a consumer has a contract, it's been someone word process, that's it. But with AI, all your material gets available kind of to the cloud, and all of a sudden, if architects start using that willy-nilly, then the private information of consumers and social security numbers and information finances have to be protected too. So we have to probably think about that as well. In our case, it's not as dramatic in your case. This is a fast once you use AI, and it gets outside that closed circuit. So
and it always has the danger of creeping outside of the areas of your control. You know, one of the things that I didn't mention is as you're dealing with companies who want to follow the rules, there are those out there that don't want to follow the rules. And if I can give you the background of Cruise Automation, it was founded by a guy who made a ton of money selling an internet streaming provider to Netflix. And he then had an idea, I'm going to make a kit that would make an Audi autonomous. And he was really, really good at it. And so what wound up happening is GM bought his company. They paid $1 billion for it. And then that sparked a lot of other young innovators in the Silicon Valley. I don't need to finish my automotive engineering degree here at Stanford. I can get 3 of my buddies and we're going to come up with a system. Well, the problem with when Cruise started, we had no ability to regulate what he was trying to do because it fell outside of our authority. And then the struggle became, how do you pull those outsiders back into your authority? I mean, I hate to put it this way, DMV was lucky. It has 270 sworn officers. And so they sent a couple of guys with badges out and knocked on his door. He was, you know, that joke about this smart kid in the basement of his grandmother's house doing things, that literally was what was going on, but he owned the house. And so they did some knocking on the door, and that basically led to him selling his company to someone that did fall within our regulatory authority.
Sunny?
In was it 2015, the legislation? So in 2015, the DMV, its overall sort of mission is essentially licensing drivers and registering vehicles. Was there a component of the DMV at the time that dealt with permitting or licensing corporations yet?
Yes.
There was.
Yeah, the mission is actually broader. DMV licenses anything that has to do with the auto industry in the States. So car salespeople, dealerships, salvage yards, auto brokers, tow yards, manufacturers of vehicles. It happens to be right now the only manufacturer actually building vehicles in California is Tesla. So some of our regulatory authority could go towards you. We can police your license, your permit to test technology. If you're building it here, we can police your permit to your actual license to actually build vehicles here. So
yeah, so I mean, just comparing it like to the American AI regulation world to like the European regulation world, you know, the American regulation model is no regulation, and the European model is, you know, that the company can do harm, essentially. But in the consumer affairs department, we're essentially charged with protecting individuals from the people that we license. And so I think that's the difference with us as we move forward that I see that is trickier, and it comes up in more than just AI, honestly. It comes up in a lot of the regulations that we do. But how do we do that? Like that we're missing that ability for that permit process for you know, the implementers of the technology, essentially. And so like getting creative and figuring out a way that we can still have a role of consumer protection in that space is, I think, our difficult spot.
that is a difficult spot because both agencies that I dealt with had a statutory mandate.
Yeah.
To regulate it. And it's interesting that you mentioned what happens in Europe. When I went to the Privacy Protection Agency, you know, data privacy and what you share on the internet is already heavily regulated in Europe under the GDPR. And so as we started looking at it in California, you did have what was lucky for us, we had the warts that Europe had already seen
dealt with
what they were dealing with. And again, in that example, we started looking at, and I mentioned the California Privacy Protection Agency, knowing what's going on nationally and looking at what's happening in other states to learn from them. Colorado was very advanced in what they were doing. There were things that were happening out of Georgetown University, and it was actually speaking with not only sister regulators in this state, but those from other states that are also tackling similar problems.
Thank you.
Mm-hmm.
Any other questions or comments? So Brian, I had a few observations. And I concur with what everybody said. Thank you again for a great presentation. So part of the idea of regulating is regulating what? And so I kind of just did this. I had this long conversation, quite honestly, with ChatGPT about this and how what aren't we asking?
Mm-hmm.
And it kind of identified just a few areas. And I'd like to get your feedback. One was professional oversight. And so, again, we're regulating the practitioner, not the tools. Mm-hmm. But what does that professional oversight look like? And so and this is a broader question, should a firm be required to inform its clients that they're using artificial intelligence? And I struggle with that question because my feeling is that I don't tell my clients who my employees are. And I don't tell them that I'm using AutoCAD. And so at what point does AI become an outlier where you're not thinking of it the same way you're thinking about other tools? And when in the evolution of your engagement or DMV's engagement, did you realize that this is not the same conversation? This is a completely different conversation. You have to approach it differently and think about it differently. The second thing Robert mentioned, this the whole thing about data and IP safeguards and privacy issues. The last one is just, what are the ethical standards that we should be thinking about? And how did you guys establish ethical standards with manufacturers? And then I think the overarching piece of it for me, though, is at what point should we be, you mentioned sort of your other stakeholders, and I see there too. There's the product side of the industry, and then there's the user side, and then there's the regulatory side. And for me, I basically said, where is the where do jurisdictions, what's their role in this process? What is the California State licensing? California state architect. What's their role in regulating and engaging? And I would be curious to know how they're basically dealing with this on a large, more public projects. So I think that when you say stakeholders, there are a lot of us. The building department industry. What is it called? What is the building department called? California Building Standards Commission. So what's their role? And so when you basically said that you work with UC Berkeley and some of the other stakeholders, how soon in the engagement did you guys reach out to those people?
The statute was signed by Governor Brown at in September of 2012. The first meeting of DMV statewide steering commission was probably in January of 2013. Immediately formed a group that included we had a representative from the National Highway Traffic Safety Administration on the initial meetings of that statewide task force. Unfortunately, he got recruited by Google and taken off our task force. But it was something that happened right away, and it was just sitting back and knowing, because we were, as you're probably familiar with, when there's legislation that's going to impact what you do, you get to give some evaluation, and we, being a part of the governor's control agency, would do our legislative analysis. And so we already knew what was going to be our problems, as the statute was going on. And so we're very equipped to quickly take action to try and form a group to deal with the task that was coming at us. So, and with that, it was like, who are all of the entities that are going to be touched by this? CHP, PUC, Caltrans, the city of San Francisco took a large part, Metropolitan Transportation Commissions, and formed that big kind of a body. It can be unwieldy. And so we used it as having quarterly meetings and then having deliverables that could go back to the body to get input. One of the biggest tackles for us was, since we regulate the licensing of the operation of the vehicle, how do you think of the technology as a person? And how do you treat something that is not a person as a person? And that is what the big struggle is. How are we going to treat it as a person? We had to think of the standards consistent with the laws that are already in existence. How do we do that? And we pushed that responsibility basically back on the licensee. You have to assure us that this vehicle is going to operate as we would expect a person to operate. Now, the interesting thing is, everyone thinks that because it's based on technology, it's based on an artificial intelligence, it will be safer. And that's the biggest argument. It's safer, it's faster. But with the technical restrictions that we have as an agency, we just had to rely on, we're going to treat it as if we were treating a human operator. And the only thing that we can do is discipline you as we would discipline a human operator. You mentioned the ethics. That is still a discussion that goes on today, and it goes back to the old trolley car problem. The trolley car is running out of control, and you can throw the lever and it's going to go left and hit a platform full of people, or it'll go right and it'll hit one person. What's the right decision? We call that the grocery cart of oranges. There's a self-driving car driving down the street, and there's a stroller with a baby in it, or there's a grocery cart with oranges. What's the right decision to make? Does it hit the grocery cart and damage the car? Does it hit the stroller and hurt the baby? Is its mission to protect the vehicle and its occupants? I don't think anyone's come up with that answer yet. And then of course that leads to the whole question of who's liable when something happens. Right now, everything's based on fault. Right. An accident happens because of something that a person did or didn't do. What happens when it's the vehicle, and whose fault is that? Is it the person that owns the car?
Yeah, and we just had a conversation about the whole idea of responsible control. And so it's still our opinion, I suspect, that the practitioner is the person who
Yes.
controls the lever. But we should also mention that the governor signed an executive order just months ago that allowed the jurisdictions of both Altadena and Pacific Palisades to use artificial intelligence to do plan reviews in an effort to accelerate the permitting process in Los Angeles. So we know it's at our doorstep. And so my feeling is that, and I tell people in my office all the time, is that you're not at risk of losing your job to artificial intelligence. You're at risk to losing your job to the person who knows how to use artificial intelligence when you don't. And so I'm of the opinion that it's our responsibility to be forward thinkers, to think about what's coming, what's out there, and be a little bit, have some foresight. And so I appreciate your willingness to come and speak to us this morning, this afternoon. So,
You know, one thing that I would add to that foresight is who's checking the results of that artificial intelligence programming. And you might want to think of yourself as that's what our role is. Is what they come up with, does it meet the standards that it should? Is it right? And as a regulator, you know, that's when you start talking about what is my technical expertise to have some comfort with the product that's being presented to us as being, you know, the adequate plans. Does it meet the standards that we would? And you have to, as the regulator, come back and say, I'm going to put some eyes on this and see that this product is what is in the best interest of the public.
thank you. So I think, are there any other questions from the board? Are there any questions from the public and present in the room? John, please state your name, please.
This is the WebEx moderator. I apologize. We can't hear online.
Hit the red button, the button's at the end.
Okay, there we go. Okay. John Roshinsky with the LATC. Yeah, we are very interested in this. We see a number of issues that are very pertinent to our industry as well. I can also tell you that the American Society of Landscape Architects has just come out with an official policy on artificial intelligence and how it affects the profession, and outline some of the key issues that they will continue to track in that regard. One comment that I would like to make is, and I agree with you, it's a tool. However, we are starting to see, especially in regards to services to the public, there are a lot of unlicensed individuals that are starting to use this technology to basically provide design services to the public, and in some cases going as far as actually developing construction documentation with this, with very little oversight whatsoever. And that's definitely an area that we are very serious in addressing at some point is how do we draw that line between what we're actually regulating versus public beware, so to speak. So
I agree. Thank you.
And maybe that is an example of trying to think of if it is a service and you're providing a product that requires someone to have a license to do, even if they're using something that's artificial intelligence to do it, is it still something that a license is required to do? Because having the license provides the oversight protection. And in that example use, if they're coming up with something and doing design specifications and it's not from a licensed entity, should that be allowed to happen? And that's
And there are those exceptions where a license is not required. And so that portion of the consumer population is at greater risk, quite honestly. Are there any other comments from the public present? Seeing none, moderator, can you open the virtual portals for any public comment, please, or questions?
Yes, this is the moderator. WebEx If you're logged in via WebEx, you can click on the hand raise feature, which should be bottom center of your command screen. And if you're calling in, *3 to raise your virtual hand. No request for public comments from online.
Very much. Thank you, Brian. I appreciate your time.
Thank you. Thank you for.
So we will move the agenda. And so next is to review actions from our last board meeting. And I'm going to basically take as you guys can just review that quickly. What's our time? I know there's a time constraint.
I think hoping to wrap up by 2:30 or.
Okay. That works.
Is that what you mean?
Okay, thank you. Okay, thank you. So again, we're on our action for our August 21st board meeting minutes. The chair will entertain a motion.
I'd like to move that we accept the minutes from our previous meeting.
Been moved by Member Ward, seconded by Secretary Brass. Call for the question. Roll call, please. Oh, I'm sorry. My apologies. Thank you. And it's right in front of me. The chair will entertain any public comment from those in the room. Seeing none, moderator, can I ask you to open up the virtual portals for any public comment?
Yes, the instructions are on the screen. If you're logged into WebEx and would like to participate, click on the hand outline or press *3 if you're calling in. No requests at this time.
Thank you very much. Madam Secretary, take the roll, please.
Ron Jones,
Yes?
Victoria Brash, yes. Tian Feng,
Yes.
Leonard Manukian, Robert Pierman,
Aye.
Amanda Stoudemire, Rod Spies,
Yes.
Sunny Ward.
Aye.
Motion carries. We will now go to agenda item I, the committee reports from NCAR. I'm going to ask the executive officer to provide us with an update.
Sure. I actually don't have a lot for mine. Robert Pearman and I sit on the same committee this year. We're both on the credentials committee, so they'll be having a webinar soonish to talk about the elections process for next year. I don't have anything else. I don't know if any other members are serving on committees that have any updates for us, or Tion, if you have any updates on your service. No, nothing.
And Tian, would it be appropriate to, this is a question, to include Westcar in this conversation as well?
Sure.
And Tian, is there a report for Westcar?
I'm no longer active. I'm a past executive committee member. So I don't have anything to report specifically, but I can report to you that we are going to have another executive committee meeting 2 weeks from today or so. If California board has any suggestions, I can bring this as extra official past chair to the committee and introduce into an agenda item or just bring up a discussion. But I'm also serving on the national board. There are no specific, in terms of among the topics that we discussed during the past board meeting, there's no particular concern that this board is concerned that we need to respond to. So there's no particular item I can report on, but if you're interested, I can respond to any questions.
Thank you. So again, Tian is making himself available for any questions regarding NCAR, regarding any questions or comments for Tian. Seeing none, I'll go to the public for public comment. Are there any comments or questions from the public in the room? Seeing none, I would ask the moderator to open up the virtual portals for public comment.
This is the moderator. The instructions are on the screen for your reference. If you're logged in and would like to participate, click on the outline of a hand, or if you're calling in, *3 to raise your virtual hand. At this time, there are no requests for public comment.
Thank you very much. We'll move on to agenda item J. I'm going to ask the executive officer again, and I think we have, we're looking at for any comments or reports from other committees, like LATC, I think particularly.
The LATC was the only committee I think that met during this period. I think Professional Qualifications Committee we covered at the last board meeting, if I remember correctly. So LATC met in October at Merritt College. It was a beautiful campus. We did a tour of their new like the horticultural program, that part of the campus, and that was definitely a highlight of the meeting. It was really nice, a really beautiful campus, and a very impressive program. LATC talked about a few of their strategic objectives, but a lot of the time was spent discussing an item on the agenda for today, which is the potential approval of the UCLA Extension Certificate Program. This is an item LATC debated. They have authority in the regulations to approve certificate programs, and there's one right now in California at the University of California at Los Angeles as a way, as one of the pathways into licensure as a landscape architect. And there's a lot of materials in the packet, the report. LATC appointed a visiting committee with one LATC member and then 2 other experts to do the review of the program. The program did a presentation at the LATC meeting and kind of did a very thorough discussion of the issues raised in the background paper here. And LATC did recommend approval of the program. They recommended a 5-year approval, but in reviewing the regulations a little bit further after the meeting, the board is able to approve them for 6 years as the term of approval rather than 5 years. It's not open-ended. It's either like a probationary 2-year, which doesn't seem appropriate given the review, or a full 6-year approval. So that is the issue for the board today. And Kim McDaniel, the program manager, is here if you have any questions about the review process. And then John Roshinsky obviously was at the meeting and participated in this and is very familiar with it.
So I would open the floor to both John and to Dr. Daniels, if you guys want to comment.
John Roshinsky, LATC. The LATC is in full support of approval of this for another accreditation period of what we thought was 5 years, but if it is 6 years, we have no issue with that. The only concerns that we did have is that the director of the program recently retired, and one of the requirements of certification for the program is that that position be filled by a licensee. We've been assured that the UCLA Extension Program is in the process of hiring a licensee to fill that. We just want to make sure that the actual criteria that's required for the certificate is met, and it appears that the intention is to meet all of those requirements. So,
thank you.
President.
Yes, sir.
So you appointed me as a liaison member to the LATC. I was there during the full proceeding. I want to commend the volunteer and the LATC's committees conduct very thorough. I call them a NAB-like program review and organize the document that is easy to follow. It's attached here. And the discussion was thorough, and the decision made was also, I think, well thought. So I recommend that the board take action to adopt at some point when it's ready, I make that motion to adopt the LATC's recommendation for UCLA's program. a side note is in the audience, the both program leader of the landscape architecture program and also the university's academic officer being present, answering questions and provide very tangible informations that helped LATC to arrive at that recommendation.
Thank you. We will open the floor for public comment for those in attendance. Seeing none, I'm sorry, Robert.
So did you say this is the only landscape architect certificated program in the state?
Yes, as an extension certificate program. They're degree programs, but this is different. This is for people that hold the bachelor's degree, and then it's an additional certificate on top of that.
Can people participate remotely? So it can.
They do have a hybrid program. Yeah.
Thank you.
Moderator, can I have you open the floor, open the virtual portals for public comment, please?
Yes, this is the moderator. The instructions are on the screen for your reference. If you're logged in, you can click on the hand raise icon to raise your hand, or *3 if you're calling in to raise your virtual hand if you would like to participate in public comment. No requests for public comment.
Thank you. So I'd like to make a motion that we approve.
I would make a motion, the board to adopt recommendations of UCSF or UCLA's extension program, landscape architecture as recommended by our landscape technical committee.
Just to clarify that it's for a 6-year term.
Should we, or just simply refer to their
So
recommendation?
the LATC approved a 5-year extension, but just in further review of the regulation, we don't have that ability.
Amend my motion in a 6-year term. Should I also mention then, subject to the fulfill the position of the program chair? Oh, this is already in their recommendation.
It's in the report.
Okay, so
Yeah.
strike the late half.
And we did discuss this with Pamela Brief, the chair, and then with John before this meeting to make them aware of the difference between the 5 and 6
Okay.
years.
Do you want me to repeat the motion or it's okay?
I just went fine.
Okay, good.
Thank you.
I can second that.
Been moved by Member Feng, second by Member Ward. Madam Secretary, if you take roll. Again, oh, I'm sorry. Again, we'll open the floor back again for public comment on the motion for those in attendance. Seeing then, I would ask the moderator to open the virtual portals as well for public comment or questions.
Yes, this is the moderator. The instructions are on the screen. Press that hand icon to raise your hand, or *3 if you're calling in. No requests at this time.
Thank you very much. Take roll, please.
Ron Jones,
Yes.
Victoria Brash, yes. Tian Feng,
Yes.
Leonard Manukian, Robert Pearman,
Aye.
Amanda Stoudemire, Bob Suisse,
Yes.
Sunny Ward.
Aye.
Thank you very much. Motion carries. I will now move to agenda item K in the executive officer's report. Next, Mr.
Thank you. Okay. So I'll just run over the highlights of the report, which is in your packet. Let's see, as we discussed, LATC met on October 21st. So that was its final meeting for the year, and the board is finishing with this meeting. We recently released the fall issue of the newsletter for the Architects Board. You can see down at the bottom of the first page, we are doing some increased outreach. So thanks to Tim from our staff for doing a lot of this. I'll be attending one as well this week at East Los Angeles College. I sent out a letter to all of the architecture programs maybe a few months ago about the recent changes to our regulations about expanding the credit we grant for community college, and then the changes to the exam eligibility and allowing candidates to test at their choosing. So we've had a lot of good response, particularly from community colleges asking for more information. And that's why we're doing the outreach presentations. Moving on to the next page, you can see our social media information. And we have both the board and LATC in here, and you can see, looking at LATCs, they've done a really good job with their social media, in particular their LinkedIn. So that is something we can aspire to do as well. They put a lot of time and effort into it. After that, you have just the update on our regulations. We've had a lot completed earlier this year. And we have one item later in the agenda. So moving on to our licensing and exam statistics, you can see our CSE statistics, which stay pretty consistent. And then the ARE data on the following page, under table B and C, you can see the difference in table C between the California pass rate and the national pass rate, which fluctuates, but generally speaking, it's always a little bit lower at the state level. Following that, you can see data for the CSE and then landscape architect data as well. Any questions? And then moving on to enforcement, you can see our complaint statistics with our most common violations to the top, which stay fairly consistent and pretty similar for our landscape architects, with the difference being in no continuing education for landscape architects. And then following that, you can see the enforcement actions taken towards the end of the report. Any questions from members?
Any questions? I actually want to applaud the departments and its staff, both for LATC and for architects, in our efforts for community outreach, engagement with community colleges. I've been present at a few of these, and I'm excited by the level of engagement. I think that the social media outreach is starting to demonstrate how the investment pays off. So I applaud both sides for doing that and would encourage just us to continue down that path. I know that it was shared with us that there's already several additional engagements with the community colleges that are already on the books. And the idea, Laura, that you sent out additional communications just speaks to what I hope to be an ongoing effort. I did mention to the AIA in my meeting with them last month, or at their meeting, about trying for them to better engage community colleges. Certainly they have student AIA at most of your programs, but they've agreed to basically elevate their outreach to community colleges. And I would hope that we would be a part of that exercise or that partnership.
Okay. Oh, that would be very helpful, because I think that kind of fills the gap too, that we hear from some of the community college students about how they find opportunities and get engaged in that aspect of the profession. So that's great.
Thank you. I will open the floor for public comment for those in the room. Seeing then, I would ask the moderator to open up the virtual portals for public comment.
This is the moderator. The instructions are on the screen for your reference. If you're logged in and would like to participate in public comment, click on the icon of a hand. If you're calling in, *3 to raise your virtual hand. There are no requests at this time.
Thank you. We will go to legislative updates. And again, Laura, you seem to be in the spotlight once again.
We talked about some of these in more detail at the last meeting, so I'm just going to give you a status update since the legislature adjourned for the year mid-September, and the governor had until about mid-October to finish taking action on any bills the legislature sent to him. So the first one, which we talked about, I think, at length at our last meeting, is AB 667, which was about allowing interpreters on license examinations or certain types of exams. This bill did not make it out of the legislature before the deadline, so it is possible it comes back next year. The board did express some concerns, so we'll definitely continue to watch that and engage if it moves forward next year. But they are, will come back in January, so there'll be an update at the next board meeting. The second item is AB 671. This bill was signed by the governor. This requires a local building department or permitting department to allow a qualified professional certifier to certify compliance with certain tenant improvements for restaurants. The qualified certifier is a licensed architect or engineer, so we will do some outreach to licensees to let them know about this change.
Can I ask you a question about
Yeah.
that? Particularly, so are they requiring that the architect or whomever the certifier is have CASP certification?
I don't know. I would have to check.
Right.
Yeah.
Okay,
I don't think it specifies that, but I'll verify and send out an email.
thank you.
Did you say governor signed or did not?
Did, yes.
Did.
Any other questions on this one? The next item is Assembly Bill 742. This would have required licensing boards to expedite applications from individuals seeking licensure who are descendants of American slaves. The governor did veto this bill. Some of his concerns were, as we qualify more people for an expedite, the benefit of expediting the license application diminishes. And also that could potentially lead to a fee increase if there's a need for more staff to process applications at a faster rate. So the next item is Assembly Bill 759. This was sponsored by AA California, which we've talked about. This is authorizes the architect in training. The governor did sign this bill. It'll take effect in January 1, 2027. So the board will start working on its regulations, has already started working on them to implement this. So we'll have the package at the next board meeting for the board to approve the language so we can move forward with that process.
What's the leeway we have for fees?
They'll do a workload analysis to see, like, we identify what work we need to do, what the tasks are, and then how much it costs us to do that. And then that's how we establish the fee. Any questions for members on this one? Okay. AB 1341 by Assemblymember Hoover. This bill also did not make it out of the legislature. This is one that AA California was a supporter of, as well as some of our affiliated professional groups. And it would have allowed the contractor state license board to take action against licensees who violated other practice acts like ours. This was placed on a suspense file. I don't remember offhand what the cost was. So I would imagine there were concerns, I think, from labor as well on this bill. So I think it is more policy related than fiscal, but it is possible this one comes back next year as well. So we'll keep watching that. And then finally, SB 641 by Senator Ashby. The governor vetoed this bill. It would have authorized DCA boards to waive the application of certain requirements when there was a declared federal, state, or local emergency for people in a disaster area. So there was also language relating to the Department of Real Estate appraisers, and that appeared to be what the governor objected to. So it would have been helpful to have this language to kind of be ready when there's an emergency versus waiting for a governor's executive order. So hopefully this comes back again, but that's all I have on the legislative items.
Thank you. Are there any questions from the board? Seeing none, are there any questions from the public that are in the chamber?
This is the WebEx moderator. The instructions are on the screen for your reference. If you're logged in WebEx and would like to participate in public comment, click on the icon of the hand or press *3 if you're calling in. No requests at this time.
Thank you very much. So we will move on now to regulatory updates from Mr. Rhoda.
And this is related to the handout.
Yep.
That I passed out. We did update the language yesterday. This was brought to the board at its prior meeting. There were concerns about clarifying the roles and responsibilities and who would take on those roles and responsibilities. We narrowed this down to be the assistant executive officer who'd be delegated the authority should we not have an executive officer present to handle disciplinary actions that have been delegated.
Perfect. Any questions or comments from the board? Robert?
So do you envision we would at some point pick an interim or acting, or just
Yes.
when the occasion arises, say that's the person?
This would be if we do not have an executive officer through retirement, we would have the assistant executive officer be able to continue the practice as board needs until the board itself appoints an interim.
I guess my question is there any value to having a calendar date or duration of that role?
I wouldn't think so because we don't know how long that's going to be. Just the process to hire and replace an executive officer is unseen. So
And is there any disadvantage to not having? I mean, my fear is that the public says, well, you have a vacancy for 3 years. So there's no statutory requirement, regulatory requirement for filling that. I mean, we just talked about this with landscape architects in the absence of an administrator for a role that's critical to the success of that department. How do we address that gap? And if it's not necessary, I'm open to that too.
I'm not sure that would be necessary because the executive officer is a critical role for the board's functions. And when one it does become absent, it is the highest priority to get that position filled.
I would say, yeah, I haven't seen it left vacant for very long at any of the boards. If the board felt more comfortable, you could put some kind of time frame and they're tying it to at least appointing an interim at the next board meeting, but I don't think it's necessary.
I'm looking for a solution where there's not a problem. So yeah, I'm just making sure that we don't see it as a problem. Okay, thank you. We should open it up for public comment for anyone in the chamber.
If we're going to take action on a motion, then we can just have public comment
after the motion.
Yeah,
let's do that.
I could read a suggested motion if
Please.
you would like. Move to approve the proposed regulatory text for section 103, direct staff to submit the text to the director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing if requested. If the board does not receive any comments, providing objections or adverse recommendations specifically directed at the proposed action, or to the procedures followed by the board in proposing or adopting the action during the 45-day comment period, and no hearing is requested, then the board authorizes the executive officer to take all steps necessary to initiate the rulemaking process, make any technical or non-substantive changes to the package, and adopt the proposed regulations at section 103 as noticed.
So moved.
Second.
Been moved and properly second. We will open the floor for public comment for those in the chamber.
This is the WebEx moderator. The instructions are on the screen for your reference. If you're logged in and would like to participate in public comment, click on the outline of a hand. Those who are calling in, *3 from your phone. There are no requests for public comment.
Thank you very much. So we will move the agenda. Oh, I'm sorry, we didn't vote. Roll call, please.
Ron Jones.
Yes.
Victoria Brash, yes. Tian Feng.
Yes.
Leonard Mnuchin. Robert Pearman. Amanda Stoudemire. Yes. Bob Spies.
Yes.
Penny Ward.
Aye.
Motion carries. We will now move to agenda item.
I'll do one thing really quick.
Yeah.
I'd like to introduce our reg counsel, Sam Singh. He is who I work with very closely to develop regulations and work through these packages.
Awesome.
He's been a very valuable resource.
Thank you.
Sam.
Thank you, guys.
So we'll now go to the review of future meeting dates. Laura, do you want to?
Sure. I have the meeting dates in the packet. I don't have locations. These are tentative dates. I adjusted them a little bit from this year's schedule. Only since we moved the last meeting of the year to November instead of December, which I think is great for scheduling purposes. But then I spaced them out so they continue to be 3 months apart rather than this year we had 2 meetings that were 2 months apart. It just didn't seem quite as necessary. So our first meeting would be February 26th, I think keeping with Thursdays, if that is the board's preference. I think our next meeting location would most likely be in Southern California. If members have any suggestions, or I can work on that and send out to the board members for a location. But if no one has any issues with the dates, we will continue planning for these.
Thank you. Any questions or comments? Awesome. Thank you.
Thank you.
So now we will go to the election of our 2026 board officers, and I will turn the floor over to Member Ward.
Yes, thank you, President. The nomination committee received nominations over the past 2 weeks for election of new officers for this year. There were, I believe, 4 nominations to keep the current slate for another year, which would be President Jones, Vice President Pearman, and Secretary Brass. And we did have 2 other nominations that were retracted. So as of right now, the nominating committee would like to put forward a re-election of the existing officers.
Thank you. Are there any questions or comments from the board? Are there any public comments in the chamber? Should we do a motion again first?
This is the WebEx moderator. The instructions.
One second, please.
Oh, sorry.
Yeah, I think probably if we're doing it in this matter, we should make a motion to.
The nominating committee would like to make a motion that we re-elect President Jones, Vice President Pearman, Secretary Brass for another year.
Second.
Been moved and properly second.
Now, very briefly, is there any member that would like to vote on those nominations separately? Hearing none, I think we can move forward.
Thank you. So now we will open the floor for public comment for anyone in the chamber.
The WebEx moderator here. The instructions are on the screen for your reference. Click on that outline of a hand or press *3 from your phone if you would like to participate. There are no requests for public comment. Turn it back to you.
But ask Secretary Brass to take roll.
Ron Jones,
Yes.
Victoria Brash, yes. Tian Fang,
Yes.
Leonard Manukian, Robert Pearman, Amanda Stoudemire, Rod Suisse,
Yes.
Sunny Ward.
Aye.
Thank you. Motion carries. Thank you guys for your continued service and your vote of confidence in our leadership. Thank you. So we will now go into closed session, or do you want to suspend?
Yeah, so you have the opportunity to either decide if you want to go back in the closed session to complete the 2 cases, or I can send them out for a mail vote, so you have more time maybe for deliberation. So we have a little bit of time constraints. You would have maybe about 40 minutes or so in closed session before you would have to adjourn for members' schedule.
I'm fine either way. Quite honestly, I thought that the cases were pretty clear for me anyway. But I think I'll defer to the board. But I guess my only, just as a procedural matter, when we're sending these out in the mail, there is no deliberation. There's no discourse amongst the board. And so that would be, just to be clear, in my opinion, that's a disadvantage of sending them out. Michael, did you have something?
I was just going to say that this, unfortunately, this conversation isn't on our agenda. I would suggest that you discuss this. I would suggest that we adjourn the open session and that you and the executive officer discuss this.
I appreciate that.
Yeah.
Okay, so do I need a motion to adjourn? No, thank you very much to the public and to the moderator. The meeting is formally adjourned at 1:48 p.m. Thank you.